but they chose these independent experts who did an analysis. And it was those independent experts that came in and said, you really shouldn't even consider these maps that were submitted by the Republicans because they do not meet your criteria of partisan fairness, and really dug into that.
Oh, interesting. Okay. So then what happened?
So then the Republicans in the legislature started to panic. I
Welcome to Law and Chaos. Today, we'll take a field trip to Wisconsin to discuss the recent redistricting decision from the state Supreme Court. Wisconsin's legislative maps have been wildly gerrymandered for 20 years, netting Republicans controlled both houses of the state legislature without forcing them to get a majority of the votes. But thanks to the recent election of a new Supreme Court justice, that's now over. Voting rights expert Jamie Lynn Crofts will break it all down for us. We got a lot to cover, so let's get after it. Hey guys, it's Liz Dye. Before we get to the interview, let's talk for a sec about the 3 Trump cases which are theoretically proceeding to trial, unlike the one in D.C., which is on hold. There's a lot going on here, a lot of moving parts. It's chaotic and confusing, but don't worry, I got you. So let's start in New York, where jury selection was scheduled to begin on March 25th to try Trump on charges that he created false business records to cover up that Stormy Daniels hush money payoff. We talked about it last week with former Manhattan prosecutor Diana Florence. I'm really proud of that episode. You should definitely go back and listen if you missed it. But after we recorded, the district attorney dropped a letter in which it consented to a 30-day adjournment of the trial because the U.S. attorney had just handed over 100,000 plus pages of evidence to Donald Trump. Trump moved to dismiss the case because he says this new evidence proves that the prosecutors failed to comply with their own discovery obligations. The prosecutors, that is the state prosecutors, blamed Donald Trump because they said, look, we handed over everything that we asked for and got from the feds. The feds didn't give us everything that we asked for, but we gave you, Donald Trump, everything that we had from the feds in June, and you didn't say that there was anything missing. Presumably, the stuff that's handed over has to do with Michael Cohen's prosecution for lying to Congress, Michael Cohen's prosecution for the illegal campaign contribution, which is the same Stormy Daniels payoff, right? So Trump got all of that stuff in June and didn't say, hey, there's missing stuff here. Instead, he waited till January to ask the U.S. attorney to turn it over. And then when the U.S. attorney said, hey, give us a second, he said, cool, and consented to multiple delays in production, which meant that this stuff didn't arrive until 5 minutes before the trial was supposed to start. So the district attorney said, hey, man, that's on you. Justice Merchan has now adjourned the trial for at least 30 days and told state prosecutors to hand over all the evidence of their interaction with the U.S. attorneys. And he's set up an evidentiary hearing on this issue for the 25th. So, big hot mess here, although I would suspect it will shake itself out without too much delay, unless the district attorney's office is lying like crazy. But I mean, that seems unlikely. Okay. On to Georgia. As we discussed with Georgia defense lawyer Andrew Fleischman a few weeks ago, there's been this ongoing motion to disqualify the entire Fulton County District Attorney's Office because DA Fani Willis was involved in a romantic relationship with Nathan Wade, the special prosecutor hired by her, to run the case. I did a deep dive on this one for Aaron Rupar's site, Public Notice, that comes out today. But in brief, Mike Roman is one of Trump's co-defendants. He's a shady campaign guy. He used to do Oppo research for the Koch brothers. He was really big in disseminating the claim in 2008 that Democrats were engaged in racist intimidation of, people at the polls because a couple of guys from the new Black Panther Party opened the doors at a polling station. And I think it was in Pennsylvania. Anyway, that was bullshit, but that didn't stop Roman. And he also flogged a whole bunch of lies about election fraud and played a key role in the fake elector scheme in 2020, which is how he found himself on the pointy end of this RICO indictment. So Roman filed a motion to disqualify the Fulton County District Attorney's Office in January because he said Willis had a financial stake in the case because her boyfriend was, using all the money he billed for harassing Trump to fund their life together. In reality, Willis and Wade never lived together. They never commingled their finances, whatever. That was bullshit. But initially, Roman's motion looked like uncorroborated stuff that he had gleaned from Wade's sealed divorce filings. And so the other defendants kind of stayed a little bit away from it for a minute. But on MLK weekend, Willis took to the pulpit of a historic Black church and gave this fiery sermon calling out the defendants in this case for racism and saying that they only attacked Wade because he is Black. After which Trump filed his own motion to disqualify Fani Willis based on both the claim that she was in this relationship and also Georgia's prohibition on prosecutors making public comments which are prejudicial to cases before them. All right. So, I think it's important to note that two things can be true at once, right? Like the attempt to weaponize a Black woman's personal life can be and was unspeakably gross and vile. And also, this was an insane lapse of judgment on Willis and Wade's part, right? Just because it didn't prejudice the defendants, and we'll get to that in a second, it was a stupid risk to take on the biggest, most public case of every single person here's career, right? These were lawyers, they knew better, and that's basically what the court said. So on Friday afternoon, Judge McAfee released his ruling. He said there was no proof that the relationship predated Wade's hiring in 2021 and that the financial benefit to Willis was minimal because, they mostly split their bills. It wasn't like, he was using this to take her on luxurious vacations. It's like maybe she had $10,000 like that he subsidized of their travel together, but she also bought trips and it was de minimis. So there's no proof of actual conflict because, she didn't have a financial interest in the outcome of the case. But Judge McAfee wrote, this finding is by no means an indication that the court condones this tremendous lapse in judgment or the unprofessional manner of the district attorney's testimony during the evidentiary hearing. Rather, it is the undersigned's opinion that Georgia law does not permit the finding of an actual conflict for simply making bad choices, even repeatedly, and it is the trial court's duty to confine itself to the relevant issues and applicable law properly brought before it. He also said that her speech in the church was inappropriate, maybe even inappropriate enough to result in bar sanctions and or a gag order. So you can bet your bottom dollar that Trump and the rest of them are going to move for a gag order on the Fulton County District Attorney's Office post haste. They're going to ask the court to ban Willis and her prosecutors from making public comments, which I don't really think it's a big deal, but it's not nice. Like if you're a lawyer, it doesn't feel good. Anyway, even without actual conflict, the court ruled that there was the appearance of conflict. That is, there's a reason for members of the public to think that Wade's work was tainted. And that undermines the public's faith in the judicial system, which, all officers of the court, but particularly prosecutors, they have a duty to ensure that there is public trust in the courts. I think the court was right about that. So Judge McAfee gave the DA a choice to disqualify her entire office or to fire Wade, after which obviously Wade quit and, his resignation was accepted. That should be the end of it. But, big asterisk here. The defendants have 10 days to ask for a certificate of immediate review, which would allow them to request an interlocutory appeal to the Intermediate Appellate Court. If Judge McAfee grants such a certificate, and I don't think that he will, this appears to be within his discretion, but if he grants such a certificate, and if the Georgia Court of Appeals accepts such an appeal, it will halt the trial in its tracks for months, which is not great, Bob. And speaking of not great, we are now in Florida, where Trump has filed a raft of bullshit motions to dismiss the stolen documents case. I think it's important to note that no normal jurist would seriously entertain these motions. They are absolute garbage. But we are not talking about a normal jurist here. We are talking about Judge Eileen Cannon, Trump's BFF in Fort Pierce. So instead, she held a hearing on 3 of these motions last week. And the first was a motion to dismiss because the charges were vague and no, these are charges for stealing documents. These are the kind of charges which have been prosecuted hundreds of times before. And, Judge Cannon did dismiss that one in writing shortly after the hearing, but she dismissed it without prejudice, which means that Trump can make this idiotic argument to the jury and hope that some sympathetic juror buys it, even though it's ridiculous. And just to be clear, jurors are tasked with determining what happened. They are tasked with assessing issues of fact. The judge is entitled to determine matters of law. And this is a matter of law that she should have decided and not kind of left out there for Trump's lawyers to try and flim-flam the jurors with and to mischaracterize the statute. This was a pretty derelict thing for Judge Cannon to do, in my opinion, and I think many people's opinion. The second motion for dismissal that was heard last week was under the Presidential Records Act. Basically, Trump says that a president can designate any record he likes as personal and just take it out of the White House with him, which, no, that's not what the PRA says. The PRA was enacted. We discussed this with Kel McClanahan a few weeks ago. The PRA was enacted to stop Richard Nixon from destroying the evidence in Watergate. So if a president could simply call something personal and, stick it in his pants pocket and leave with it, that would defeat the entire purpose of the act. The PRA says that records must be designated as personal at the time of their creation, segregated from presidential records, and usually that they fall into some very specific categories, right? They can't be like documents generated by the National Security Agency. That's not a thing. So the special counsel pointed out in his pleadings that the logical extension of Trump's argument would be that an outgoing president could designate like the entire national security archives as personal records, slide them in his suitcase, walk out the door of the White House, and then sell them to Vladimir Putin, and the Justice Department couldn't prosecute him for it, which, no, that can't be the law. That's ridiculous. Nor can it be the law that the government simply has to just keep asking former presidents forever and ever to give them back stuff they stole and just can't do anything to get it back or charge them or subpoena them. That's another dumb thing that Trump is arguing. And I guess to her very minimal credit, Judge Cannon did not appear at the hearing to be super down with that one either, although as of this writing, she has not ruled on it. And I will say a bunch of conservative groups have filed amicus briefs, making this PRA argument. It's really stupid. But Judge Cannon did appear to be receptive, at least in some measure, to Trump's claim that the case should be dismissed because of selective or vindictive prosecution. Basically, this argument amounts to saying that the government is prosecuting you in circumstances where it wouldn't prosecute other people. It is more or less impossible to win on this. Like nobody, as I recall, no one in the 11th Circuit, which is where Florida and Judge Cannon are. I don't think that there have been any successful prosecutions of this in the 11th Circuit. But Judge Cannon is reportedly entertaining the comparison to Joe Biden, who, as we all know, was not charged. So if the government didn't prosecute Biden for the documents in his garage, they can't prosecute Donald Trump. There are about 1 million reasons that this theory is garbage. For starters, President Biden voluntarily turned over classified documents as soon as they were discovered. He consented to a search of his home and his office, and he did exactly what the government asked him to do, right? Attorney General Merrick Garland appointed Special Counsel Robert Hur, who was, by the way, a Trump appointee, and Hur spent months and months investigating Joe Biden. And if there had been anything to charge with, he'd have done it. There was nothing there. And there was no evidence Biden even knew that most of this stuff was like in his garage. I mean, there were a handful of documents. It was not that much stuff. And Biden was like, I don't know how that got there. I mean, it's been there for like 20 years. In contrast, Trump knew that he had the documents and denied it and then refused to return them. He defied a subpoena. He actively hid documents from his lawyer and caused that lawyer to file a false attestation to the FBI that Mar-a-Lago had been searched and there were no more classified documents to be found there. Trump had his valets lie to the grand jury and then sent them to delete the security camera footage, which would have showed them transferring the boxes of documents into and out of that storage locker in the basement of Mar-a-Lago, which is, once again, not an appropriate place to store national security documents. So I don't understand how this can be a live motion. Like, come on, Eileen, but here we are. And all that's insane and worrisome, and does not give me hope that we are going to see a trial before this election. Although I will say, I do think New York is going to happen. Justice Juan Merchan is not fooling around. I don't think that Trump is going to be able to play the rope-a-dope on him, but we will see. But on a brighter note, our guest today has some happy news to bring us from Wisconsin. And also on a brighter note, so many of you have stepped up to support the show at patreon.com/lawandchaospod or on Substack at lawandchaospod.com that we have a lot of names to get through. We're going to keep cranking through them until we've shouted out all of you, but just thanks a lot, you guys. So specifically, thank you to, from Substack, Stephen, AHC, Wally, Gustavo, Chris, John, Eccles, Rick, Dr. Kiddo, KBH, Milton, Bruce, House of the Blue Lights, Cthulhu for Supreme Court, Melissa, Alan, Dr. BDH, Yumi, Heisenberg, hey you, I know you, DD, Rachel, Fran, and Arik. And from Patreon, thank you to Jessica, Box of Biscuits, Box of Biscuits, Box of Mixed Biscuits, Biscuit Mixer. You really do not want to know how many times I had to record that one. Timothy, R. Mortimer, Martin at the Buttons, Ted, Janice, Jazz 8500, OMG, WTF, GOP, girl same, Philip, Daka Daka Wah, Dina, Dean, Is OA Over? Don't know about that one. Colin, David, Andrew, Claire, The Running Knitter, Jesse, Hades, and Jean. So if you are a subscriber, we will get right to that interview and we will shout you out if we haven't already. And if you are not, we will be right back after we pay some bills. And with us today is Jamie Lynn Crofts, Wisconsin policy wonk and voting rights advocate. And there is no better person to get deep in the weeds on the fight that led to the state's new electoral maps with us and tell us how it will affect this all-important swing state. Jamie, thank you so much for being here.
Yeah, it is so great to get to talk to you.
All right, so let's get right into it. How bad were the old Wisconsin maps?
They were the most gerrymandered maps in the country by multiple independent redistricting experts that analyzed them. As many people know, particularly from our history with presidential elections, Wisconsin is about as close to a 50-50 state as you can get as far as Democrats and Republicans. And yet, our old maps our maps managed to give Republicans a near permanent supermajority in both houses of the legislature. They actually did have a supermajority in the state Senate and were one vote away in the assembly.
Right. They used that power to more or less override everything Tony Evers, the governor, did, right?
Oh, pretty much everything. And even crazier is when you look at, kind of the polling on certain issues and how popular they are statewide. We would have issues, like legalization of marijuana or even medical marijuana, which we don't have here. Things like abortion rights, which have extremely high popularity in the state. But when the state is so gerrymandered, the legislature doesn't have to be responsive to that.
Right. So two things happened. One of them happened in 2020 and one of them happened in 2023. And both of them involved Dan Kelly, a former judge on the Wisconsin Supreme Court.
Yes, we had a lot of good times. I guess my question for you kind of, Liz, is where do you want to start with the Wisconsin redistricting nonsense? Because there are so many different points where you can jump in to tell this story.
Okay. Well, I just want to establish, though, that the condition precedent for what happened in February is that Dan Kelly lost first to Judge Jill Karofsky in 2020 and second, Justice Patience Rogensack, who was, I think, the high justice and had an amazing name. Justice Patience Rogensack retired and Dan Kelly ran for her seat against I'm going to say it wrong. Can you say it? Judge Janet.
Well, so a lot of people just say Judge Janet, but it's Janet Protasiewicz.
I mean, I was never going to get that right, but she is now a justice on the court, and that flipped the court.
It did. And she won so big that, and this is kind of unprecedented in Wisconsin, you could get rid of the votes from either Dane County, where Madison is, or Milwaukee
Wow.
County, and she still would have won.
Oh my goodness. I didn't realize it was such an overwhelming victory. I remember it, and I, have a little crush on Ben Wickler, the head of your state Democratic Party, because he appears to be able to do anything. But
Yeah.
so tell me, all right, so tell me where you think you ought to jump into this story.
I mean, again, it's hard to say. And like, this is kind of an interesting history in Wisconsin too, because you can go back to 2010, you can go back 50 years, because
Wow.
pretty much any time Wisconsin has had a split between the legislature and the governor, a court has stepped in to draw the maps. And that has actually
Hmm.
happened after most censuses since
Oh, interesting.
1960.
Okay. And is that why you had the Republican supermajority, because all of the Republican districts?
Well, so what had happened was, and actually, I do put a little blame for this on the Democrats who were in office pre 2010 census, because
Hmm.
they had the power and they could have enacted an independent redistricting structure, and they did not, because they felt comfortable with where the state was. Then Scott Walker won, and Republicans won both houses of the legislature, and that was when we ended up with the most gerrymandered maps in the country.
What year did Scott Walker take office?
Scott Walker was elected in 2010 and took office in 2011. And that
Okay.
was also when the legislature, both houses of the legislature, flipped to Republican.
Right. And then what happened after that? All hell broke loose.
Yeah, so Republicans were like, all right, under state law, we can kind of do whatever we want here after the 2010 census, and really gerrymandered the state to hell. And that was the first instance that Wisconsin had been gerrymandered to this extent. But
Hmm.
because of the extent to which they had gerrymandered the state, and because we didn't have any laws mandating independent redistricting, when the 2020 census came around, they were able to just do the same thing all over again. Well, that's actually simplifying things and ignoring the litigation that happened post that census, because we had a Democratic governor. But
Okay. So 2020, we have this census. Trump tries to rig it. He more or less gets shut down by the Supreme Court, although that's kind of debatable. But we have the new numbers. But we also, at that point, have a Democratic governor, right?
yes, Tony Evers.
Okay. So then what happened? So what happened after that? Who drew the maps in 2020,
So,
2021?
so what ended up happening, and actually it went into 2022, was
Mm-hmm.
that so it's mandated in the state constitution that the legislature and the governor have to agree on the maps. But as
Mm-hmm.
we just discussed, that doesn't tend to happen in Wisconsin when you have a split between the parties. So it sometimes in the past has gone up to the Seventh Circuit and sometimes has gone up to the Wisconsin Supreme Court. This time around, it went up to the Wisconsin Supreme Court. And after a little back and forth that involved maps from the governor, maps from the legislature, at one point the US Supreme Court stepping in, the Wisconsin Supreme Court ended up ultimately choosing the mega gerrymandered maps that the Republican legislature had submitted. And in one of the decisions along the way, also said that they wouldn't be considering the issue of partisan fairness at all. And the criteria that they were most interested in was which maps were closest to the super gerrymandered maps that we were currently working under in Wisconsin.
I mean, that seems really a weird criteria to say, well, the closest we can get to the extant maps from 10 years ago, I mean, that's a weird, that's a weird rubric to use.
It was really strange, and pretty much it had been suggested in the litigation by the Republican legislature, and the Wisconsin Supreme Court was like, yeah, that sounds great to us, because at the time they were conservative controlled.
Okay. So was that under the theory that protecting incumbents is a legitimate map guide, or was that, was it just general cussedness? I mean, I've heard of protection of incumbents as being a legitimate rubric.
They did kind of say that a little bit, but they honestly didn't do a great analysis on why the least change standard should be used. The court just
Hmm.
kind of brushed over all of the arguments and were like, because no one can agree and this is super political and we're a court and we don't want to get into politics, we'll just go with least change, ignoring the fact that the maps themselves were inherently political.
Right. And the state has changed. I mean, that is why we have the census, right? To count and to kind of measure how the state changed. And I'm sure that the state did change quite a bit between 2011 and 2021, right?
It did. And one actually really interesting data point from that was that in a lot of places, the white population actually went down, where population in communities of color went up, particularly among people who are voting age.
Right. And I mean, it's just as a general observation, there are a lot of empty places in the country that are getting emptier, and the cities are getting generally larger, and the suburbs and even the exurbs are getting larger. But that I don't understand how there could be a map from 2011 that you could use again in 2021 or 2024 that wouldn't overcount rural areas.
Oh, right. And I mean, the court did know to the extent that they did have to do some change because the
Right.
maps were inherently unconstitutional after the new census. But they just
Right.
kind of said, we'll go with least change, and that's the most important metric to us.
Interesting. Okay, so the court says these super gerrymandered maps, which will ensure a Republican supermajority in the legislature, even if they only get like 49% of the vote, they're cool.
Yep. And really, it can be much more extreme than that. I think it was in 2018 that Democrats won like 53% of the vote statewide and ended up with 40 some percent of the seats. I mean, it was just,
Wow.
yeah, the numbers, when you look at them, just really illustrate the extent of the gerrymandering here. It just truly was extreme to another degree.
But then, as we said, something happened last year, which was that Dan Kelly lost again.
Yes. And as far as I'm concerned, he should really keep running for things.
Yeah, he's not a super sympathetic character, and now that he's got like the Scarlet L from twice getting his ass beat by these ladies who want to run against him, I agree with you. He should be a perennial candidate. He's the best. He's the best man for this job. So what happened immediately after Judge Janet took office?
So, pretty much as soon as Judge Janet was sworn in, there was a new lawsuit challenging these maps.
Mm-hmm.
And the lawsuit itself, I thought, was really interesting from kind of a law nerd perspective because it did
Love it.
challenge, right? It did challenge the maps on the basis of, their partisanship. But what the court actually decided the issues that the court actually decided to hear weren't related to the partisan makeup of the maps. The court was like, we're actually more interested in these things that are mandated in the Wisconsin Constitution, like the fact that the court enacted maps that the governor vetoed when the state constitution says that it's the legislature and the governor have to agree on the maps. They actually didn't
Mm-hmm.
end up deciding that issue in the end because they looked at the maps and said, our state constitution mandates that districts be contiguous. The maps that were enacted had all these cute little islands in them that were clearly not contiguous. And that was
Mm-hmm.
the actual basis that they used to throw out the maps in the end.
Yeah, I've heard the former Wisconsin map described as like a Swiss cheese map, and one of the districts is the T Rex district.
I am going to miss the T Rex district a little bit.
Yeah. No, can you talk to us about how bad these maps were just from a contiguity? I mean, look, let me break it down. Contiguity, just for the people who aren't deep into this map stuff, is like the districts were all spread out and they weren't even like, you couldn't walk, from one end of the district to the other, that there were all of these like little islands that were hived off from the rest of it.
Exactly. Yeah. And like some of them were based on the, like weird annexation from municipalities throughout the years and that kind of thing. But if you zoom in on the maps, there would be like one district, kind of like it would look kind of like a lake or something in the middle of the district, but it was actually another district with part of it within another district. And that was a terrible way of explaining it.
No, I 100% get it. It's funny because I live in Maryland, which is pretty substantially gerrymandered, but at least we have like the fig leaf where you can walk through it. It might be like a 1/2 block, like touching each other from two sides of the highway or something, it is gerrymandered. But at least we have the dignity to like have them be pretend contiguous.
Yeah, no, they didn't even try.
Mm-hmm. Okay. It's interesting, though, that what you're pointing out, because that is a law nerd thing, is that the case was brought on this kind of partisan, that the plaintiff said, these maps are too partisan. And the court was like, yeah, we're not going to play with that one. But how about non-contiguous? That was like probably your fourth argument, but that's the one we like. We're going to go with that one.
Yeah, and honestly, like if you look at, if you want to take this from a conservative textualist standpoint, it was an incredibly strong argument because contiguity is one of the criteria that's literally written into our state constitution.
Right, which is what the court found. Do you want to talk about the ruling?
Yeah, so the ruling itself really was based specifically on this contiguity issue. The court, and I don't know how much you want to dig into it, but I think it was pretty clear when you look at the maps and you look at that language that the districts weren't contiguous, period.
Right.
But then when the fun started was when the court said, so these maps are unconstitutional. And here are the criteria we'll be looking at when we analyze the new maps that the parties submit to us.
Mm-hmm. So what happened there?
So the court kind of laid out a list of things that they would be considering when the parties submitted maps to them. And I made a little list here so I wouldn't forget any of them. Those criteria, the criteria were obviously contiguity, population deviation. So under U.S. Supreme Court law as well as state law, the districts have to be pretty close in terms of population. Wisconsin is one of the states where we have certain areas covered by the Voting Rights Act that require majority minority districts.
Oh, interesting. I did not know that.
Yep, particularly here in the Milwaukee area. I think all of the maps that were submitted by all of the parties had at least 5 majority Black districts and 2 majority Latino districts. And then there was one map that had drawn a 6 majority Black district.
Whose map was that?
That was the state Senate map.
Interesting.
And then the other issues that they looked at were geographic splits. So that splits between, cities and counties, compactness, and not kind of doing the drawing along a block to make a really long line. And then the final one was partisan balance.
Right. So as we said, this wouldn't have happened if the court hadn't flipped. And they did indeed, this court, rule in the Johnson case in 2021 the other way and say that they weren't going to redo the maps. So the judges who, are still there now that Justice Rogensack is gone and Dan Kelly is gone, they are pissed that this has happened. And they weren't nice about it. Most of the opinion itself is like 50 pages. And then there's like 200 pages or something, like 180 pages of dissents that are like really, really mad. So I'm just going to read a little bit of one of these dissents because it's so delightfully pissy. She says, the 4 robe wearers grab power and fast-track this partisan call to remap Wisconsin. Giving preferential treatment to a case that should have been denied smacks of judicial activism on steroids, unlike everything that came before, right? The court of 4 takes a wrecking ball to the law, making no room nor having any need for longstanding practices, procedures, traditions, the law, or even their co-equal fellow branches of government. Their activism damages the judiciary as a whole. Regrettably, I must dissent. Try decaf. I have so little sympathy for something that makes the maps fairer after there's been, 20 years of partisan gerrymander and allowing the country to become totally captured. The legislature to choose its own voters as opposed to the voters choosing their own legislators. Cry me a river.
Oh yeah, and also okay, now do the U.S. Supreme Court.
Mm-hmm. Mm-hmm. Right. Or so many of the courts in this country just disregarding precedent when, to help Republicans stay in power. I have no problem with this. So, don't care about that. So the partisan balance from the Republicans' map was in their own favor.
Oh, extremely. And I thought that some of their submissions to the court were particularly interesting because one of them continued to include those little islands, despite the fact that the court had explicitly ruled on the issue of contiguity. But also, the submissions to the court really didn't even try to pretend to be fair on a partisan level, even after the court explicitly said that they would be considering it.
So I don't understand what the thinking would be. Like the court has said, we're going to fix your maps. They can't be these, concoctions that have like little islands. And what is the thinking for Republicans to be like, you know what? What if, yes, what if we just did the thing that you told us explicitly, don't do that anymore?
At the time, I was just like, wow, this is a terrible litigation strategy. I
Mm-hmm.
actually, the other day was at an election law conference where two of the lawyers on opposing sides of this case kind of talked a little bit about it and what happened. And so I'll kind of give a brief summary of what the lawyer for that side said,
Mm.
which was he basically said, so we took the requirements that the court had given and they chose to rank them in a specific order. And it was the
Mm-hmm.
court didn't give an order, but they said that when we were drawing our maps, we decided to say that, and I don't off the top of my head remember which was most important, but for example, they said we made population deviation our number one priority. After that, we made
Oh, I see.
geographic splits our second priority. And so they were like, contiguity was less important to us than the geographic splits were. So that was why we submitted their maps, was basically what that lawyer said.
It's interesting. So my son, as I've said it on air before, and I've appeared on air with my son before. So my son draws maps, and so it's interesting because in this day and age when we can have computers do all of that like instantaneously, you can kind of prioritize for whatever, you minority voting representation, you can prioritize for rural urban, you can prioritize for maintaining the county lines or the current districts, and you can tweak it so easily using computers that it used to be such an art to have somebody dedicated to this, and it was impossible to see. And now that you can tweak it, you can also back formulate it really easily and say, well, like, this is clearly what you did. It's just such an interesting thing. I understand exactly what you're saying, though, that the court gave them 7 factors and listed them, and that the Republicans said, okay, we're going to hyper prioritize for one factor and then put every other factor behind it, because doing so will give us the map that we want and give us a fig leaf to say, this is cool, we just did what the court told us.
Yep, pretty much.
Okay. But it didn't fly.
No, it did not. And so the court chose 2 experts to come in and look at the maps. And interestingly, I think only one of the parties even suggested any experts. And the experts that they chose were like not even the experts. That was one of the quote unquote like liberal challengers that had
Mm-hmm.
named them. They didn't actually choose the experts that they had asked for, but they chose these
Okay.
independent experts who did an analysis. And it was those independent experts that came in and said, you really shouldn't even consider these maps that were submitted by the Republicans because they do not meet your criteria of partisan fairness, and really dug into that.
Oh, interesting. Okay. So then what happened?
So then the Republicans in the legislature started to panic. I, I think it was after that expert report that I don't know why the writing on the wall wasn't clearer before the expert report, but I think it was the expert report that really made the writing on the wall clearer to the Republicans
Mm-hmm.
in the legislature that they were not going to get what they wanted in this litigation.
Right. Just to totally disambiguate that, it was then that the Republicans, who have been able to brazen their way through this for almost a generation now, realized that they were not going to brazen their way through, and that if they didn't figure it out, the court was going to enact a map that they really, really didn't like, and they were going to lose their jobs.
Exactly. And so there were a number of different parties and interveners and stuff in this suit. I think there were 6 or 7 different maps submitted to the court. So it wasn't just like one map from the governor, one map from the legislature. Each house of the
Mm-hmm.
legislature submitted its own. There were
To the court,
law
right? And so the
to the
court was
court.
looking at a whole bunch of competing plans, and Republicans knew that their plan was not going to get enacted, and a plan they really didn't like was going to get enacted.
Exactly. And so they were kind of at that point trying to figure out which of the fairer maps, were kind of least bad for them, I think was what
Hmm.
the Republicans started trying to figure out at that point in time when they realized there was pretty much no chance that any of the maps they had submitted were going to be selected by the court.
And just I want to point of clarification: are we talking about state and congressional maps, or just state maps?
Just state maps. There was a separate challenge filed about the congressional maps, and the Supreme Court said they are not going to take that up at this time.
The Supreme Court of Wisconsin or the U.S. Supreme Court?
Supreme Court of Wisconsin, sorry.
Okay, so the gerrymandered congressional U.S. congressional maps are still here.
Yeah, those are staying put.
Yeah, all right,
For now.
but we'll take our win where we can get it. Okay, so what happened after the Republicans were like, "Oh shit, we're all going to lose our jobs from these terrible maps,
Yeah.
terribly fair maps"?
So at this point, after that expert report, and one thing that we actually didn't talk about yet was last fall when and last summer when they at first said they were going to impeach our newest Supreme Court justice for winning an
Mm-hmm.
election. But by this point, they had dropped that because they realized just how popular she was, and that would not be a good idea politically.
Yeah. So Robin Voss is the Speaker of the Wisconsin House, and he was the one who was spearheading the move to impeach Judge Janet because she refused to recuse from this gerrymandering lawsuit. But, she was very popular, and he dropped that, but I think that comes back around in a minute. But that they had been very against her doing this because they said she was partisan, which is pretty funny from people who had enacted these partisan maps and relied on a partisan court to bless them for a couple of generations, or for at least a full generation.
Yeah, and Dan Kelly had plenty of partisan things to say during that election as well. But
Mm-hmm.
but yeah, so that had kind of happened in the background. And I feel like if it hadn't happened last summer and last fall, there would have been some discussion of it after the expert reports. But they had kind of already moved on by this point. By this point, we're in January.
Mm-hmm.
And so after all of this, Republicans are like, okay, what do we do now? And so the first thing that they did was they took Governor Evers' maps, which I think by that point they had decided of the maps that were still in consideration were kind of the least bad for them. It's
Mm-hmm.
debatable whether they are or not, but I think that that's by this point what the Republicans in the legislature had decided. But the first thing they
Right.
did was they took those maps and tweaked them to make them favor Republicans more. And
Uh-huh.
then they passed those maps trying to say, look, we passed the governor's maps, but they weren't actually the governor's maps at that point.
Mm-hmm.
So the governor vetoed it.
Okay. So that's in January, but the clock is ticking, right? Because you guys have to get your maps squared away because they have to run primaries, right?
Yep. And so the Wisconsin Election Commission had set a deadline of, I believe it was sometime in March, that they needed a finalized map by. And so that was what everyone was operating under, both, the court and the legislature. Because so we have a lot of elections in Wisconsin, but our partisan primary is for everything except president is in August. And the Election Commission basically said we need everything done, by this point in the spring so that we can make sure all of the nomination paperwork and everything is ready for when people start filing.
Okay. And after Governor Evers vetoed not his map, Republicans were even more under the gun because if they don't enact a map, the court is going to enact one that they don't like.
Exactly. And, there were some sketchy things that were done procedurally, and it was kind of at the last minute. And, I was, when this was happening, kind of sitting with people who had been really in the front lines of this fight. And we were just all finding out at the same time, like, oh my God, the Republicans in the legislature are about to vote on Tony Evers' maps, but they're actually the governor's maps this time.
Mm-hmm. And they did it.
And they did. They passed both houses of the legislature. And actually, they passed with nearly on party lines by Republicans. Only one Democrat voted for the maps in each house.
Yeah. So can you explain that controversy? Because that was a little complicated from the outside to understand why the Democrats were pissed.
It was. So part of it is just kind of this nitty gritty, kind of sketchy procedural stuff that I alluded to. So
Mm-hmm.
back last fall, there was a proposal for an independent redistricting system in Wisconsin that was voted out in the assembly, and we don't need to get into the weeds of this. It was better than what we have now, but not great.
Hmm.
It it did not go to the floor in the Senate. But kind of to avoid the committee process when the Republicans were scrambling about these maps, what they did was just replace all of the text that had been about the independent redistricting in those bill numbers with the new
Hmm.
maps.
Oh, I see. Okay.
So there was no committee process, there were no public hearings, there were no three readings. They really just did that to speed through this process. And so, with something like this, it's a very complex issue that actual documents describing these maps are hundreds of pages long. And Democrats were like, you didn't give us any time to review this. There was no public process because of kind of the history of all this redistricting nonsense, just didn't trust the Republicans that they were doing what they said they were doing when it came to these maps.
Okay. Is that why there was this movement that people said Tony Evers should veto the map?
So that was part of it. There was also some debate, and some of it was reasonable, and some of it was honestly based on, I think, misinformation about, which maps were better for the state. And some of it was coming from a partisan perspective, which maps would be better for Democrats, which if you're an elected Democrat, that's within your purview to
Hmm.
consider. But there were also issues like, so one of the maps that had been submitted, I believe it was the map that was submitted by Law Forward, had taken into consideration the staggering of Senate elections. And so it had drawn the map in a way that the upcoming Senate elections would make the Senate fairer faster versus having
Okay.
to wait two more cycles of Senate elections because it's a third of the Senate is up for reelection every 2 years in Wisconsin.
I see. So what they're saying is like, let's speed this up so that, we're not stuck with a wildly gerrymandered Senate. It doesn't take 3 cycles to wash this gerrymander out.
Exactly. And the governor's maps, didn't really do that the way that another one of the maps had done. And, I think there was some reasonable debate about which maps were the best as far as things like partisan fairness or as far as things like keeping particular municipal lines within assembly districts and that kind of thing. But
Hmm.
honestly, parts of it that were really frustrating for me were that some of it was just kind of misinformation that was being amplified because people understandably didn't trust what the Republicans were saying. And
Right.
so there kind of this narrative that started to come out from some people was like, these aren't actually Evers maps, these aren't fair maps, you should veto them.
Okay. So let me ask a question, because what I have read has suggested that possibly that the Republicans were just going to do this and then sue again to halt their own plan. Do you think that that's what's on the horizon here, or do you think that they are like tapped out? They know that this is the least worst thing that's going to happen for them.
I mean, I definitely think that's always something to consider. I
Hmm.
definitely agree that it is a fair concern. I don't see how that would be a good thing for them to do or a smart thing for them to do in this particular situation. I think it would have been a lot easier to try to get up to, for example, the US Supreme Court on something if the courts had actually been the ones that decided the final map by
Hmm.
making various arguments with, our hyper partisan US Supreme Court that we
Right.
have.
Right.
I think that doing it this way through the process that's actually mandated by the Wisconsin Constitution, passed by the legislature, signed into law by the governor, is a lot stronger than a court decision that either could go up to the US Supreme Court or it could just come back up to the Wisconsin Supreme Court because we have Supreme Court elections starting next year, every year until 2030.
Oh, interesting. That makes complete sense. And also, I mean, as you pointed out on social media, if Governor Evers had vetoed his own map, that would be politically disastrous. You can't ask him to veto his own map. That doesn't, and then go back to the Supreme Court and say, I'm coming to you in good faith, having presented this map to you, and then vetoed it. That was a terrible position for him to be in. He couldn't possibly have done that.
Oh, I thought that was absolutely laughable. Like the governor is party to this litigation. You want him to veto his own maps and then what? Go back
Right.
to the court and ask for the relief of them enacting the same maps that he just vetoed?
Right. That's impossible. So let's talk about what the result will be of these new maps, at least, yes, even though it's going to take 3 cycles to wash out.
I mean, this year, the assembly really could go either way. And that is the first time in a long time that that's true.
Are enough seats up that it could do that, that it could flip the House, flip the assembly?
Yeah, every assembly seat is up for election this year. So
Oh, I see what you're saying. It's only, sorry, to be clear, it's only the Senate that has staggered elections, and the House is up it's like the U.S. Senate and House. Got it. Okay, so the entire House is up, and it could flip this time.
yeah, it absolutely could. Wisconsin is like most states in that there is kind of a small geographic advantage for Republicans just because a lot of the Democratic votes are concentrated within cities.
Mm-hmm.
That said, these actually are fair maps, and Wisconsin is such a close state that it really could go either way this year.
Right, and it's a presidential year, so turnout is going to be, through the roof.
Yep. The Senate,
Okay.
unfortunately, we're going to have to wait a couple of cycles for it to even out.
Got it. So just as a funny little coda here, what happened to Robin Voss after all this fun times?
Well, the extremist kind of election denier part of the Republican Party has been mad at him for a while now because they don't think that he was a strong enough election denier. And so there are people on the kind of extreme right side of the Republican Party who are trying to recall Robin Voss and get him removed from
Mm-hmm.
office.
Mm-hmm.
The man who has been the most powerful Republican in the state since Scott Walker lost re-election.
And totally a true Trumper, right? He was involved in some of the litigation to overturn the election, if I'm correct, right?
No, Voss kind of stuck his toe in the election denier nonsense. He
Mm-hmm.
himself never said the election was stolen, but he did appoint retired state Supreme Court Justice Michael Gableman, who put
Oh, that's what I'm
together
thinking of.
just a ridiculous horse and pony show, trying to claim that there was fraud, and that's why Joe Biden won the state in 2020.
Do you think that Voss is actually going to get recalled?
Well, I'm not sure. And so what's interesting is this is going to be another thing that is headed up to the Wisconsin Supreme Court because
Mm-hmm.
of the redistricting and the redistricting lawsuit.
Oh, because is he in like 2 districts or something? It's not clear where he's going to have to run.
Well, it's not clear whether the recall should take place in the district that he was elected from, that he is currently sitting in, or the new
Mm-hmm.
district that he will be in when these new maps go into effect.
I don't even understand how that's a question. I mean, just like from a logical standpoint, shouldn't you, like, if you're being recalled, shouldn't you be recalled by the voters who sent you there, not the voters who might send you there in the future?
So I think that's a strong argument. But also, when the Wisconsin Supreme Court threw out our existing maps, they said these maps are unconstitutional and not to be used in any future election.
Oh, I see. Okay. I guess the recall is an election. Sure. I guess it's like something that you vote on. That is such a weird question. And I mean, we could certainly get in the weeds on that. I would be extremely interested to feel that one out. But I think the sense is that he's probably going to survive, right? I mean, he's pretty powerful.
Yeah, I think that he will probably survive the recall. I do think that whatever his upcoming primary ends up looking like will be interesting
Mm-hmm.
because, assembly districts are relatively small. And 2 years ago when he was running, Donald Trump actually personally endorsed his primary opponent. And his opponent
Everything
did come with,
Trump touches dies.
yep. And his opponent did come within a few hundred votes just because, when you think about how small an assembly district is in the turnout for an August primary, those races are decided by pretty small margins. So I think he would survive a recall election. I don't know that he'll survive the next Republican primary.
That is wild. Completely wild. Okay. So, from a policy standpoint, what is this going to mean other than that the legislature is probably not going to be constantly overturning anything that Evers does by veto?
I feel good about it, but, it's one of those cautious optimism things,
Mm-hmm.
particularly like we've already touched on. It's going to take a while for the Senate to catch up as far as the fairness goes.
Right.
So that's something that we need to contend with for the next several years. But the fact that we have
But
these fair maps now, and people know that when they're running for reelection, they're going to be running in these new districts, I am hoping that we can at least get some decent policy things done at the state level that we haven't been able to thus far. With these fairer maps in so many more districts, the general election is going to be competitive. And so,
Mm-hmm.
whereas in the past, the Republican primary has been the most important election in so many of these districts.
Right. And that drives the most insane, I mean, particularly in the Republican Party, that drives the most insane, fringy weirdo. It propels that fringy weirdo into office because you never have to earn a single liberal vote, Democratic vote. You just win with Republicans. And so, the crazy wins.
Exactly. So, I am feeling hopeful that there are some good things that we'll be able to get done that we haven't been able to in the past. And, there are just so many issues that are so incredibly popular statewide. I mean, it's so funny whenever I go to Illinois, people will be like, oh, do you guys have recreational marijuana yet? I'm like, we don't even have medical. You can be dying of cancer in Wisconsin and you cannot legally get medical marijuana here.
And that might change. I mean, that's always, it's like I talk about my son. My son is like, medical marijuana, such a winner everywhere, every cycle, put it on every single time, or any kind of marijuana laws, because there's such broad favorability for legalization in the country that, we should put it on every time and raise the minimum wage.
Yes. And then another thing that Republicans have been doing that I'm really hoping these new maps will put a stop to is that since they weren't able to overturn Evers' vetoes because they didn't have a supermajority in the assembly by that one seat,
mm-hmm.
What they have been doing instead is putting terrible things to a statewide referendum and writing them into our Constitution. And
got it.
That has been kind of their way to get around the governor. And of course, the way that these questions are written when they're on the ballot is not clear. It's confusing. It's not even the same language that's actually written in the Constitution that is what's given to voters to summarize the question that they're answering. And for the most part, they've been putting these questions on the lower turnout elections and not like, for example, in November of a midterm or presidential election year.
Mm-hmm. So that will be changing the legislative mix will help curb that?
I'm really hoping. So like one, for example, things have to pass the legislature in 2 consecutive sessions before they go to the voters in Wisconsin for a constitutional amendment. And so there was one that they passed last fall, and we do 2-year legislative sessions here in Wisconsin. So there was one that passed last fall that would have to pass again in 2025-26 that would codify our terrible voter ID law into the state constitution.
Oh, I see. That's interesting that you guys have that break, that it has to go through the legislature twice before it goes to referendum. I wasn't clear on that. So, right, I see now how that would be. I mean, most places, I think it's like referenda are by signatures or some other type of thing. There isn't that legislative stop against referenda.
Right. And that's actually another thing that activists and even the governor have tried to get for us in Wisconsin is citizen-led referenda, because right now they have to go through the legislature. There is no way for people to get a binding referendum statewide.
All right. Well, I am very optimistic. Anything you want to plug here on your way out the door?
Liz, it is always great to chat with you and kind of get into the weeds on some of these legal and policy issues. And I'm glad you had me on today. It was great to chat.
All right. Thank you so much for being here.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright 2024, Raise Ipsa Media, LLC, all rights reserved.